NACDL is the association of the nation's criminal defense bar.
I am so honored to be moderating this discussion, and I'm really excited to hear from today's speakers. Before we begin, I'm going to take just 6 minutes to provide 3 pieces of context that I hope are useful for today's discussion. And to do that, I'm going to share some slides. So the first point of context, the speakers are going to be talking about different stages of the jury selection process and what can go wrong at each of those stages. So as context for that discussion, here is a brief overview of the stages of jury selection. So first, there are the non-public stages of jury selection. These are decisions executed by the jury clerk or the jury commissioner at the direction of the chief judge or sometimes a committee of judges, and often pursuant to statute. These non-public stages don't always occur in the same order, but they always include one, the selection of source lists, so lists from state agencies that will serve as the source for juror names. So for example, a jurisdiction might get the list of registered voters from the State Board of Elections and the list of licensed drivers from the Motor Vehicle Department and use those as the source for juror names. Then there's also a stage where the jury office removes from the source list people who don't meet the eligibility criteria for jury service. So in most jurisdictions, for example, you can't serve as a juror if you are not yet 18 years old or if you've been convicted of a felony. So at this stage, people who don't meet those requirements get excluded from the jury system. And then next, using this smaller list of people deemed qualified to serve as jurors, the jury office summons people. It sends out notices, jury notice to the address that they have on file. And at the next stage, the jury office processes the responses they get or don't get to those jury summons. And those responses include, for example, requests to be excused, sometimes because the financial burden of jury service is too onerous. Sometimes it's just a request to defer jury service. Sometimes people don't respond, and a certain portion of those jury mailings are returned as undeliverable by the Postal Service because the address was out of date. So all of these non-public stages of jury selection produce a group of people who arrive at the courthouse on a given day prepared to serve as jurors. This group is sometimes called a veneer, but jurisdictions use different terms, so that's not always the term for it. But it's at this point that the public stages of jury selection unfold. Public in the sense that they take place in the courtroom, in front of the judge and the lawyers and the parties as a part of the voir dire process. Now, of course, there's some people who arrive at the courthouse in the veneer who don't go through the voir dire process and are simply sent home because the court has enough jurors. But for those who do go through the voir dire process, it includes a step where some jurors are removed for cause, which means one of the lawyers argued that the juror could not be fair, and the judge agreed, and the judge excluded that juror. And at the final stage, some jurors are excluded through peremptory strikes. So this is where the lawyer decides to exclude some potential jurors on the grounds that they think they won't be good for their case. And only after all these stages of jury selection are completed do we end up with the actual trial jury who will decide the case. Now, for the second bit of context, our speakers are going to be referencing the legal requirements for jury selection, both how to enforce those legal requirements and what we might need to do above and beyond those requirements. So here is a quick overview of the legal context for jury selection. First, there's a right under the federal Constitution to equal protection of the laws under the 14th and 5th Amendment. And this gives us the right to a jury selection process that's free from discrimination. This right applies to both civil and criminal cases. It applies in federal and state courts, and the right can be enforced by the parties or the would-be jurors. The right to equal protection, to a process free from discrimination, extends to every stage of the jury selection process. And state constitutions contain a parallel equal protection right, so parties in state courts can also make that state constitutional claim. Second, there's also a constitutional right under the 6th Amendment to a jury selected from a fair cross-section of the community. So this imposes an affirmative duty on the state to produce a jury system that includes a fair cross-section of the community. They have to reflect the diversity of their communities. This right applies to all criminal defendants in federal and state court and can be enforced only by criminal defendants. The fair cross-section right extends only up to and including the veneer. It does not cover the voir dire process. State constitutions contain a parallel fair cross-section right. So again, state court defendants have a state constitutional claim they can raise. And then finally, in federal court, there's a federal statute. It's called the Jury Selection and Service Act of 1968, JSSA. And this statute applies both of these rights, the right to a process free from discrimination and the fair cross-section right, to all federal cases, civil and criminal. And in many, but not all states, there is a state statute that parallels the JSSA. So the key takeaway is that all these constitutional and statutory provisions add up to two key legal requirements. The first is that the jury selection process must be conducted without discrimination, and the jury system must include a fair cross-section of the community. The third and last piece of context that I want to raise is the legal standard to prove a fair cross-section right. And I'm pulling out this one and highlighting it in order to emphasize the way that it differs from the standard for equal protection violations, and because the fair cross-section standard functions as an obstacle to fair cross-section claims. So when I ask our speakers about obstacles to jury diversity, it'll be helpful to have this in mind. So to make out a prima facie fair cross-section claim, a criminal defendant needs to do three things. First, identify a distinctive group in the community, say African Americans. And second, show that the representation of that group in the jury system is not fair and reasonable. And this is done by comparing the percentage of a distinctive group in the community to the percentage of that group in the jury system. And third, the defendant needs to show that this underrepresentation is due to systematic exclusion. That is something inherent in the jury selection process. So unlike in equal protection, the cause does not need to be discrimination. It doesn't need to be intentional at all. And if the defendant makes this showing, they'll prevail unless the government can show that the exclusion manifestly and primarily advances a significant state interest. Okay, so with that context in mind, I'd love to turn to our speakers and ask some questions. So today we're going to be talking about steps that jurisdictions can take to increase jury diversity. And I'd like to start by asking Professor Valerie Hans to share some data on why exactly jury diversity is so important.
Sure, I'd be glad to do that. Let me share some slides with you. And here I really want to draw on research that's been done over the years that shows why the kinds of things you're talking about, that the procedures and the laws that we have in place to try to maximize the chance of representative juries is really so important. And you know, if you will, we're asking the question, if you can see the slide here, we've got 1860s slide of an all-white, all-male jury from England, and a representative jury on the right-hand side of the slide. And really, we're asking the question, are the decisions of those two kinds of groups going to be different? In fact, they will be, and in addition, there will be other positive consequences, research shows, for having representative juries. First of all, and I'll go into this in more detail in just a minute, it turns out that diverse representative juries really strengthen the fact-finding process for a couple of reasons. They improve the quality of the decision and reduce the likelihood of bias in the decision. But they have other effects too. The fact that we have a representative jury in place deciding cases increases the legitimacy of the trial. It also, because it includes a broad range from the community, has the ability to educate a number of people from all walks of life and parts of our community about the law and how it works in practice. We know that serving as a juror actually winds up improving views about the courts that people hold, and that service on a juror which is a form of civic engagement, encourages other forms of civic engagement. So it's a really it's a kind of intriguing institution that is bolstered by representativeness, and that also works to bolster some of our most important democratic values. So to offer a concrete illustration about how it works and how jury diversity strengthens fact-finding, I want to describe results from a mock jury experiment that was conducted by a terrific psychologist named Sam Summers. He decided to do a mock jury experiment to explore the impact of diversity, and in particular racial diversity. And he developed a video of a sexual assault trial with a Black defendant, and assembled people drawing from the community at large that were either in groups that were all white or that were mixed race groups. So here you see on the screen, the all white juries were 6 people of the same racial group, all white. And then in contrast, there were diverse juries with 4 white people and 2 African Americans. And so mock jurors sat in these groups and watched the summary of this trial with a Black defendant. And then what Professor Summers did was to compare what happened and, looking not only at the judgments, but also at the deliberations. And he discovered that being in a diverse jury had some striking effects. First of all, there was an anticipatory effect. Even before they actually met with others on the jury to start their deliberations, the white jurors on the diverse juries were less committed to convicting the defendant in the case. So simply anticipating being in a group where one would have a diverse a deliberation with diverse others seemed to affect their initial views about how strong the evidence was in the case, as they anticipated having to formulate their judgments and defend them in this diverse group. So you can see that Black jurors, in the African American jurors in these diverse juries, were the least likely to convict the defendant in anticipation before deliberation. White jurors and all white juries were the most likely, and the white jurors on diverse juries were in between. But they also found some individual differences in the deliberation itself. And what you can see here is that the intriguing thing here is that although Black jurors definitely contributed unique things to the deliberations, one of the fascinating things was that the difference in white jurors in terms of context. Those who are on diverse juries raised more novel case facts. They had fewer factual inaccuracies in the claims that they made, and cited more missing evidence. So kind of an interesting phenomenon. The context really encouraged more careful deliberation. Just one example, I think it's a really clear example, which is backed up by other research as well. I have to mention, though, that there are these other effects of having diverse juries as part of our legal system. One is the legitimacy and confidence in the verdicts that are reached. And I think we saw that in the Chauvin trial. When verdicts are reached in racially charged cases, if you have a diverse jury, there's more confidence and respect for the verdict. And the courts themselves benefit from this diversity of the decision-making by juries, especially among racial minorities. So jury service educates people about the law, boosts voting, and other forms of civic engagement. So in short, not only are the outcomes in our legal system enhanced, we also promote democracy by ensuring that there are diverse juries.
Thank you so much. I think we'll continue to be talking about the benefits that we get from jury diversity. And actually, let me just pause before turning to the next question. Paula, was there anything you wanted to add to that point about the value of jury diversity?
I think Valerie covered it quite well.
Okay, great. Well, now I'd like to ask you a question, which is, all right, jury diversity has all of these wonderful benefits, and you have expertise from working with courts all over the country. So I'm curious to know what you see as the primary obstacles to jury diversity. And I'll just note before you answer that tomorrow's session is going to focus on two specific obstacles, one which just came up in the Q&A, the exclusion of people on the basis of language proficiency, and also the exclusion of people with felony convictions. But sort of aside from those two, what are the obstacles to jury diversity?
So I want to just starting off that most of my experience at the National Center for State Courts is working with that upstream, the non-public portion of how juries are selected. And I think that's actually pretty important for particularly the folks in this audience to understand, is that there's a lot that goes on before the panel actually shows up in the courtroom. And it's a pretty complex process that jury managers are trying to do. So the major obstacles, and I also want to step back a little bit and just talk a little bit, because you made reference to the fair cross-section case law, the legal context. And I think one of the things to sort of understand is that we tend to think about fair cross-section as a very aspirational, that we want our jury pools to really be mirroring the full breadth of our communities, the demographics, the attitudinal diversity, socioeconomic status, basically all of that, so it actually feels like our communities. The legal framework is actually to be able to prove or establish a prima facie case that there's been a violation of the fair cross-section requirement is actually a pretty heavy lift. And in some sense, I think that the legal framework is itself kind of disincentivizes a lot of courts from doing as much as they could to make sure. And I particularly want to call out that third prong. You mentioned that third prong of the test, the fair cross-section test. It actually comes from Duren v. Missouri, which was a case that the U.S. Supreme Court decided in 1979. Basically says that the underrepresentation of this distinctive group, whatever the distinctive group is, has to be due to systematic exclusion. So it's just inherent in the process itself. It doesn't have to be intentional discrimination. So first, let me say that we're actually really fortunate today. I see almost no instances of intentional discrimination and haven't for decades. I can think of only one example that took place in Illinois back in the early 2000s. And that was one that actually it was a clerk of court that was actually trying to fiddle with the veneers that were going up to the courtroom to make sure that there were enough African Americans on panels that were going up for criminal trials. So that basically ended up with her going to jail for jury tampering. But we don't see intentional discrimination. And a lot of the factors that actually undermine representation in our jury pools actually fall under that larger rubric of non-systematic exclusion, typically because they involve, you mentioned earlier on about issues about undeliverable summonses, non-response and failure to appear, and excusal rates. These tend to be really heavily correlated with socioeconomic status, as well as correlated with race and ethnicity. And so what we see is, because it is technically those are not a violation if undeliverable rates are very high or if non-response rates are high. Typically, those tend to be explained away, at least in case law, as an example that this is not something that the court has control over. The court does not have control when people move and don't leave a forwarding address. The court does not have any control of when people fail to appear. The court doesn't have any control over their socioeconomic status that would, legitimately make it quite burdensome and a hardship for people to be able to serve. So that's how the case law has tended to go. And unfortunately, I think it has meant that for some courts that they have sort of dismissed that of, well, nothing I can do, not my problem. And the result is actually some, quite often when we look at these courts, that we can look at underrepresentation, particularly of people of color, and be able to point to those very factors that greatly undermine, underrepresent people of color in the jury pools. And unfortunately, by the time they actually get up to a courtroom, we'll hear about that, tomorrow and the following day about peremptory challenges, is that nothing that happens from that point on tends to actually reverse the damage that happens upstream.
Well, if I can ask a follow-up, because one of the things that we hope to highlight today are things about the jury process that people might not know, or find surprising. And your response just highlighted one that I think might be surprising to some people, that regardless of the way the fair cross-section test is applied, there actually is a number of things that courts can do with those non-public stages of jury selection that could improve diversity. Do you mind just giving a couple examples of that?
Sure. Undeliverable summonses, again, tends to correlate really highly with socioeconomic status, as well as age. So people who are younger, they tend to be renters, they tend to be more mobile. And so just catching up to them. This is actually an issue that's related to the accuracy of the addresses that are coming in on the source list. So whether they're coming from driver's license or registered voters or any other lists that are being used. And one of the problems with them is that there's not really a good mechanism for getting those updated. So for example, with voter registration, the voter, Secretary of State, they actually only care about the address because they want to know that the person who is voting is going to the correct precinct. Other than that, they're not that concerned about the accuracy of it, because it's up for the person to actually show up at the precinct and vote. So they're not thinking about it as is this an actually a useful, valuable, quality address to actually mail a summons for, to let somebody know that they need to appear for jury service. And so people who vote infrequently, don't necessarily have a good address from the voters list. If you've moved recently and are you updating your driver's license? Well, most people don't update their driver's license until they actually have to renew it. And since 2008 and during the recession, a lot of states increase the interval for renewing your driver's license from, it used to be like 4 or 5 years. Now some of them it's as much as 10 years. And when you think about it, and every single statute says something about, within 30 days, you need to update your list. But the main thing that was incentivizing people to do that was back when you wrote checks and somebody would ask for your ID to check to see if it was the same address on your check. And so I ask anybody, when was the last time that you actually wrote a personal check that somebody asked to see your ID because they wanted to check the validity of the address? It just doesn't happen anymore. And so those lists are not particularly good. So there's techniques. One of them is just updating that master jury list more frequently. Most states now do it at least annually, although there's a number of states that do it, as much as every 2 years. But when you think that about 10% of the US population moves to a new address every single year, that means that by the end of the year, even if you could start with a perfect list, perfect addresses, you would have 10% of your summonses coming back as undeliverable. And if it gets to the end of 2 years, you can, you imagine how that compounds. So one is just updating the list, and then the other one is also to use what's called the National Change of Address, where you can actually upload the list or upload, a bunch of summonses, and to vendors that are licensed by the U.S. Postal Service to check to see whether or not somebody has actually submitted a forwarding address because they've changed their residence. And it's actually quite inexpensive, particularly doing it in bulk. But that can actually, get you, as you're 6 months in or 9 months into your list, to be able to update so that you're actually able to deliver the summons to someone.
Thank you. That's really interesting. I've learned a lot from you and your work about some of these administrative changes at the non-public stages of jury selection that can make a difference. And as you were pointing out, it can have a big impact, particularly since nationally the residential mobility rates differ by race and they're lowest for the white population. So if addresses aren't updated, it could have an inadvertent disproportionate effect. In thinking about solutions, and I want to keep talking about that, I wanted to ask each of you whether you thought there were any particular opportunities presented by this specific historical moment, either in light of the Black Lives Matter movement and the attention that's brought, necessary attention that's brought to racial justice issues, or courts' response to the pandemic. So Valerie, perhaps I'll turn to you first.
Yeah, it's I think really been fascinating to see how courts have responded to the COVID-19 pandemic. So for all the people who are on this webinar who were struggling through trying to respond and keep our courts going during this pandemic, kudos to you. It's really been fascinating. So one of the things that I've seen is virtual jury selection, which has had mixed responses from the lawyers who have to try to assess juror fairness and whether or not jurors are fair and impartial when they are little boxes on a screen. But the interesting thing that I have seen is that when virtual jury selection was foisted upon some of the litigants, judges often responded by saying, okay, we know that there are these challenges now to courtroom jury selection, and we want to be sure to maximize the representativeness, even though we know COVID's probably going to interfere with it. And they allowed more expansive pretrial juror questionnaires with the kinds of questions that actually would tap potential bias in cases. I mean, as you may know, many courts have a kind of desire for efficiency to kind of get through jury selection quickly if people are right there in the courtroom. But I think the move to pretrial jury questionnaires that allow this broader range of questions to be asked is really one of those things that I hope stays in the future because it's going to help us impanel fair and impartial jurors. One other thing that I wanted to say about this discussion about the non-public nature of this early stage of jury selection is that, boy, how are lawyers supposed to get information about the representativeness of the panels and the veneers and the different stages? Unless there's some access to them. Federal courts and state courts are different on this particular issue. And I think particularly in state courts, it's very difficult for lawyers to get even basic information about how representative the groups were. So I think that's an obstacle. And I guess the solution would be for courts to open up some of the information in those early stages. Paula, how about you?
You were mentioning sort of the really creative use of juror questionnaires and how to do jury selection online. I will say the National Center's been, sort of working with some of the courts that have done that. And we haven't compiled all of the data yet. But one of the things that I'm actually hearing pretty consistently, anecdotally, from the judges and lawyers that have participated in jury selection remotely, is that the people who show up, the prospective jurors who show up, they uniformly say they've never actually seen that level of diversity in court jury selection. So the remote jury selection is just so much more so much more convenient for people to be able to take the time out from home or from work to be able to participate. And I think it really addresses some of the issues that we've seen both with excusal rates and with failure to appear and non-response rates, is that when we can actually make jury service so much more convenient in terms of time, it doesn't involve transportation to the courthouse and parking and taking an entire day off from work, that perhaps that's something that more courts can think about, because once you actually can engage with them online in person and get the judge and the lawyers telling them something about the case, and being able to have that discussion with jurors about, if you were selected as a trial juror and having the trial in person, then you can actually work with them about sort of what other barriers that they might have, that you don't get that opportunity when they just simply ask to be excused or don't show up at all in the courthouse.
Yeah. It seems so obvious in retrospect, but I got to say, I never would have predicted that would have been one of the outcomes of a major health pandemic.
And the other one is just in terms of the Black Lives Matter and sort of just the increased interest and attention to racial justice in the American justice system, is I've been really heartened by the number of states that have put up task forces and commissions, and really starting to lean into of saying, yeah, this is one of the many areas, but we need to do a better job with our jury system, because this is where public trust and confidence that we need to have a diverse pool and be able to demonstrate that we have a diverse pool. But this is also the experience with, and you mentioned it in your talk, of like jurors that come in and actually get to participate firsthand in the justice system, end up leaving with generally much better perceptions about the fairness and integrity of the process, and they in turn then can be sort of the ambassadors to their respective communities, their neighborhoods, their employers, about what the justice system is, because they've actually participated firsthand. And so it really does make a difference, and I think courts are really trying to lean in right now on this issue.
And I think another thing the Black Lives Matter movement has contributed to is now a better understanding about bias, especially implicit bias or unconscious bias, and how our traditional ideas of overt prejudice don't really capture all the ways in which race and racism affect our judgments and decisions.
Yeah, I think I would add, I think I'm allowed to add something as a matter, that the Black Lives Matter movement also contributed, I feel like, an awareness that it's not simply a matter of, are we engaging in explicit racism? Because as Paula said, that's less of an issue for these non-public stages of jury selection. But are we carrying the status quo uninterrupted when the status quo itself has inherited or taken the baton from structures and systems that were unjust? So, for example, the idea of many at least federal systems relying on voter registration lists as the source for jury names, when voter registration, as one of the comments in the Q&A pointed out, is in turn affected by efforts to suppress the Black vote or efforts to limit voting. And so I feel like one insight that I've gotten from the Black Lives Matter movement is, unless we recognize that the status quo has some of that built in, and so it might require a fresh look even in the absence of explicit racism, that's something that we need to be doing. Is there anything that you have learned? I mean, you mentioned discovery, so this is what, when we think of this, anything you've learned about obstacles to jury diversity, litigating fair cross-section claims that might surprise people, or myths about jury diversity that you'd like to dispel? Like, this is your moment, you have the audience.
Well, one misconception actually, Paula and I collaborated on clearing up, and that's the idea that if you have a diverse jury that represents people who are very different, you're going to have more hung juries. And in a research project we did some years ago in a number of jurisdictions that were quite diverse, we found, and we looked at felony jury composition and then the outcomes of these felony juries, and some, of course, a modest number were unable to reach a verdict. Most did reach verdicts. And we found no relationship between the extent of diversity on the jury and the likelihood of having a hung jury. So I want to lay that misconception to rest with Paula's help.
I think for me, when I think about particularly the non-response, because it is disproportionately people of color, and it's a major contributor to underrepresentation. But there was some very good research that was done in the late 90s by the American Judicature Society that looked at non-response and failure to appear rates. And one of the really striking things that came from that study for me was that once you controlled for socioeconomic status, a person of color, African American, Hispanic, Asian, and a white person were equally likely to fail to appear. And so I think that really does, emphasize the extra burden that jury service has on people who are at the most fragile level of the socioeconomic, status. Of what it means for them to just have to take time off from work or organize childcare or just the public transportation to get from wherever they live to a courtroom, disproportionately hits people of color. And that's why we actually see, see them disappear from the jury pool because of non-response and failure to appear rates. And I think really just when you start to look at what the average, just compensation in terms of service are and how that contributes to the burden of jury service for people who are at the lower rungs of our society. The average juror fee is $22 a day if it's a flat fee. And if you're on a graduated, so you get little or nothing on the first day, and then something on the second day, it's only $32 a day. Average per capita income is something like $120. And so we are really pushing jurors very, heavily in terms of what the out-of-pocket means. And, jurors have not gotten a raise in decades, when you start to look at this. Terms of service, when we ask people to come in for a week at a time, for 2 weeks at a time, to put themselves on call for, in some courts up to 6 months, that is tremendously burdensome. And so I think that it really does point to some areas of sort of the surprise that this is not that people of color are inherently less motivated to be good citizens and to be good jurors. But it really does hit them much harder in terms of the economic impact on their lives to be able to participate. And I think points out to things that we really should be doing in terms of compensation and reduced terms of service.
Those are such good insights. And I would add, just going to the discovery point that you raised, Valerie, I think another myth that I would want to dispel is the myth that a defendant needs to show that there's something wrong with the jury system before getting access to information about those non-public stages, that the fair cross-section right doesn't exist if you don't have access to jury selection records. And there's good case law from the Supreme Court on this point, but there's a lot of big misunderstanding of this issue because there's something that feels unusual or burdensome about responding to what could feel like a fishing expedition, but there's really no way to find out what's going wrong without access. So I would love to see that myth dispelled, that you have to prove a problem before you can find out if there's a problem. I, of course, have so many more questions I want to ask you, but I want to turn to the questions in the chat too, and I really encourage anyone in the audience to ask questions in the Q&A. So I'm seeing here a few questions about source lists in terms of how voter suppression might affect the voter source list, and whether suspended or revoked licenses might affect the source list of driver's license. So just any thoughts you have about problems with source lists or good solutions, perhaps if you've seen things in jurisdictions that you think could serve as a model for other jurisdictions?
Well, one of the ones I think if you are just relying exclusively on the voter list, that would be as the sole list, and I think a lot of the federal courts still do that. There's very few of the state courts that rely exclusively on the voters list. But certainly to the extent that voter suppression is putting barriers for people of color to be able to even register to vote or to stay on the voting lists, that yes, that would definitely contribute to. Again, whether this is how that works into the legal framework. Do you actually have to have a court case, that says, yeah, this is a voter suppression, a violation of the Voting Rights Act, or can you simply take judicial notice of the fact that there are barriers to people voting? Most states and a healthy proportion now of the federal courts actually use multiple lists. So they're using voter and driver. A number of them are starting to work with state income tax, which is actually really good because the addresses, people do file their taxes every single year. So you know that you're getting it updated. And if you don't file your taxes, they will come looking for you. So I think that's, those are some of looking at different lists and looking at what the list priority is of which address you're going to retain. If you have people who are, drivers and voters and state income tax filers, you probably want to go with the list that's on the income tax as opposed to other ones. So, there are those. With the driver's license, I think you would actually just have to ask what are the criteria that they're asking of the state Department of Motor Vehicles. Many of them are just getting all of the licensed drivers. And I would mention that because the DMV in most states also manages people who are not licensed to drive but have a state identification card, that they manage both lists and they provide both of those for the juror source list. But I don't tend to see as much unless there's been a specific request of don't give us, inactive or lapsed license holders. So there may be some discussion there that if somebody has not renewed their license in a certain period of time, that probably they've moved to somewhere else, and so they're going to just keep that because it would probably be a bad address. But so I don't think that some of the problems with the driver's list, but you would have to ask and find out exactly what the data requirements are that are being data files that are being sent over.
It's certainly important to have that focus on the source list because the jury system is never going to get more diverse than the source list. So that makes sense that we're seeing questions here. There's another question about whether where are we seeing the bulk of exclusion of, I'm going to frame it as communities of color. Is it happening more in these non-public stages? Is it happening more during the peremptory challenge phase? If you know the answer or have, or any guesses, would be interested.
Paula, do you know?
I've actually never seen a good study that's put it side by side. So I don't know the answer. I would suspect it would depend on, the jurisdiction that you're talking about and the practices. So particularly in the jury selection, in the voir dire process, who gets removed for cause and who gets removed by peremptory challenge is probably going to be, heavily affected by the kind of case it is, the the race or ethnicity or gender of the defendant, the length of the trial. People who are, again, sort of really struggling financially, they're not going to sit on a, 2 or 3 week long trial because they probably can't afford to do that, as opposed to a 1 or a 2 day trial where you could probably get people. So
yeah. Sorry, Paula. But the analyses that I've seen that go back some decades showed drop off in representatives at just about every stage, starting with the source list and, moving on to the summoning process and non-response or undeliverables and exemptions and exclusions. And then the courtroom jury selection, the public part that we now know more about. So I guess my exhortation to people who are in courts, if you're not already doing this, I would say, we need help. Let us know. Start counting, and give the rest of us a sense of where in the procedures that you have set up are you seeing departures from representativeness? Because I think if we knew that, we would be able to target particular more effective remedies for it. And it honestly, it could differ quite a bit across jurisdictions. Some jurisdictions might have great source lists that capture the public, whereas others might have, I'm thinking of differences between rural and urban areas, for example, a much higher, more mobile population. So I think please start counting and share the information. That's step one.
Yes, it's always key to emphasize the importance of data collection. I saw a point in the chat about whether a jurisdiction collects race and ethnicity data from the beginning. I think we're seeing some movement around that. Some states recognizing the importance of that and adding it in. It's certainly key. Paula, there's one question that I just wanted to turn to you because there's a question about whether or not there's an organization that has a resource about how each state collects prospective jurors and compensates them. So can you give National Center for State Courts a shout out here?
Sure. For anybody who is not familiar with the National Center for State Courts, we have a sort of a section of us within the National Center called the Center for Jury Studies, and we have extensive information on everything that we can possibly you could possibly think about on juries. If I could, let me just share. So one of the things we have, if I can get to it. Never mind.
We'll put a link to it in the resources that will be listed with the recording of this video for sure.
Okay, that would be great. I'm just trying to stop sharing and I can't do that. There we go. We do have sort of what we call a data viz that basically does state by state information about all things juries, but including what kind of source lists, what the juror fees are, what the term of service is, number of peremptory challenges, jury size. It's all there. So please jump on there. It's at www.ncsc-jurystudies.org. And I'll put that in the chat as well for people.
Great. Now I'm seeing a number of questions that go to the point that you raised, Paula, about socioeconomic status. So that's the real driver of these non-responses, because when you control for income, it doesn't differ by race or ethnicity. And so a couple points have been raised in the chat. For example, the California pilot program in San Francisco, which is going to pay low-income jurors $100 a day to expressly with the purpose of increasing diversity. And there's a comment in the chat, Catherine Hare, about the point that a few jurisdictions do and all jurisdictions could add lists of public benefits recipients. So my question is, what are other things that jurisdictions could do to be responsive to the financial burden of jury service beyond increasing jury pay?
I think probably one of the big ones is looking at term of service, one thing that we do know is that the length of the term of service is definitely related to the number of people who ask to be excused, as well as to what we often see in terms of FTA rates. And so just trying to reduce the burden on people by, certainly the National Center recommends, and the ABA Principles for Juries and Jury Trials recommends 1 day, 1 trial. So people, if you're summoned for jury service, you come in, you are either selected for a trial and you serve on that trial and you are done. And if you are not selected for that trial, then you are still done. And that really reduces the burden for a lot of people. Most trials in this country, both criminal and civil, are relatively short, 1 to 3 days. So that's usually manageable for most people to be able to do that. I'm really interested to see how the California group comes out. The use of the public benefits. I think the major, as a source list, the major improvement there is basically the addresses. Typically, you don't actually add a lot of unique people. It's unlikely that you will have somebody who is getting public benefits, but does not have a driver's license or a state ID and is not a voter and does not pay income tax or is filing to get their refund back. But what you do get is really, really good addresses out of it, because the people who are receiving public benefits definitely want to continue to do that. And so if they're getting a check in the mail, although I do have to think about with a lot of those of whether or not, as we get into more people just doing electronic deposits, that may not be the silver bullet that a lot of people are looking for. So I'll just add that. The other one on undeliverables that I'm actually more concerned about right now, sort of the post-pandemic, is the real surge that we're seeing on civil evictions that is just displacing lots and lots of people that are, again, at that lower strata of society. That are going to be really hard to keep up with and figure out where they are if you're trying to mail them a summons. And I don't have a solution for that.
There's another potential solution. I don't know how successful it's been, but I'd be really interested in learning more about it. And people have talked about it, and that's community outreach. If there are particular communities that are hostile to jury service, above and beyond the, oh no, I got a jury summons and how can I disrupt my life for this activity, above and beyond that might be suspicious, might be concerned about going to the courts. I think targeted participation in events with particular communities, underserved communities, or communities that are more suspicious might be worthwhile. And that could be a job for lawyers, it could be a job for people who work at the courts, could be a job for judges or simply citizens. And I've found over the years that people who have actually served on juries are among the biggest ambassadors for it as an experience. And it's kind of funny when you think about it, because our popular conception of, a jury summons is, oh no, I got this thing and I have to do it and I don't want to do it. And I'm going to be forced to do it. And then when people actually participate, they, I think, recognize the incredible respect that we have as a nation for the understanding, compassion, and good sense of the citizens to give serious criminal and civil cases to our fellow citizens to decide. And I think that can be incredibly empowering, and then have all those other spin-off effects of greater legitimacy for the courts and greater engagement with the community that we were talking about earlier.
This is just making me think of Will Snowden runs or has been running something called the Jury Project in New Orleans, which does a phenomenal job of community organizing and community education. around this. And it was featured in a book by Sonali Chakrabarti, who's a professor at Wesleyan, and has written an impassioned book about the jury and about this kind of civic education. So I just want to highlight both of their work. Tragically, we only have 4 minutes left, and Monica made me promise to give her 2. So I'll just, I have so many questions. Just give you an opportunity to close out. Like, what's your message to this audience? The thing you wish everyone knew about juries, or just your own passion for them, however you choose to use your minute.
So I'm going to put in the plug, particularly with an audience of lawyers, and I know that the court people in here are cringing as I say this. Do ask questions about the, just how the pool is done. You will, I think working collaboratively right now in this moment where courts are actually much more invested in making sure their jury pools, you may actually get a really receptive. But from the litigation standpoint, one of the things that I've seen, even though it's really hard to win a jury challenge, is that it tends to make the courts sit up and pay attention to what they're doing. And you often see real improvements in just in terms of jury operations in the wake of a serious challenge.
And I would just, I think, say, or kind of echo you, Nina, that we're at an unusual moment, and perhaps a moment, whether it's the pandemic, social and political movements, or a better understanding on the part of lawyers, judges, court personnel, and the community at large that there are lots of benefits to having our most important cases decided by juries. It's an important symbolic institution for our democracy, and we should support it. And this might be a really important moment where we can actually make some significant progress on the issues that we've been talking about over the last hour.
Wonderful. Thank you both for those closing thoughts.